All right. I'm going to ask the clerk to go first.
Court of Appeals for the 8th District of Texas is now in session.
Thank you. And the court is going to hear case number 08-20-00015-CV, Jorge L. Hernandez versus King Aerospace. And Ms. Stone, former Chief Justice of San Antonio, is going to, for the appellant, and Mr. Rose is for the appellee. Is that correct?
Yes, Your Honor.
All right, you may proceed.
Thank you. May it please the court. As you mentioned, my name is Catherine Stone, and it is my honor to represent appellant Jorge Hernandez this afternoon. I'm joined by trial counsel Ruben Valadez, Skip Good, and Humberto Enriquez, who I hope are watching the live stream. I thank you for providing us with oral argument opportunity this afternoon. As you are aware from the briefing, this case arises from a personal injury suit in which Mr. Hernandez received a jury verdict following a 5-day jury trial. But judgment was not entered on that verdict. Instead, a take-nothing judgment was entered against Mr. Hernandez. The judgment doesn't use the term JNOV. The judgment doesn't mention a motion for JNOV, nor could it, because no written motion or oral motion for JNOV was ever entered. And nonetheless, the judgment is a de facto JNOV, and that is what is on appeal today. There are three main reasons why we seek reversal and rendition of this judgment. First, it is our position that the judgment was entered in violation of the procedural requirements for entry of JNOV. Those are requirements designed to honor the jury's role in deciding factual disputes. Secondly, the judgment violates the proper standard of reviewing evidence when a JNOV motion is filed, and is thus an improper JNOV. And then finally, these fatal procedural and evidentiary review errors have burdened, they're not matters of mere formality, they have most definitely burdened Mr. Hernandez, and he has suffered harm as a result. So if I can address all three, I'll try my best. I'll talk as fast as is reasonably possible. The procedural errors is the first topic I would like to discuss, and a little bit of factual background is appropriate to fully understand the procedural errors. As you know, Mr. Hernandez was injured when he fell while working on an aircraft at Fort Bliss. He was part of a team of expert, experienced aircraft repair mechanics who had worked for ATG, Aviation Technologies Group, and they were working on a project that the Army had contracted with King Aerospace to perform some maintenance and repair work. After he was injured, Mr. Hernandez sued King Aerospace for negligence, and King Aerospace claimed that Hernandez was its employee and claimed the workers' comp defense of exclusive remedy. Case went to trial, and the jury charge asked in the very first question, was Mr. Hernandez working as an employee of King Aerospace on the occasion in question when he was injured? Employee was defined, borrowed employee was defined. There is no question or complaint by any party about the definitions given or the instructions given in the jury charge. This charge was answered by the jury. Question number one, they found that Mr. Hernandez was not an employee of King Aerospace at the time that he was injured. That's kind of the factual background relevant, I believe, to our complaint about procedural errors. So the procedural errors can be summed up actually rather quickly. For starters, there were 3 oral requests during the course of this 5-day trial, 3 oral requests for a directed verdict by King Aerospace. And each time that request was made, it was denied. It was first made at the conclusion of Hernandez's offer of evidence. And here's what the court said. deny. I'm going to carry it with the case. Let's see what the jury does. At the time of the entry of judgment, I'll give you a ruling. But here's what he also said, and this is a direct quote. I'll give you a ruling, but you have to move for a JNOV. That is at volume 9 of the reporter's record, page 28. Another request for oral request for directed verdict was made at the time that King Aerospace finished its evidence. And the motion was, I'm going to move again for a directed verdict on my affirmative defense, to which the court said denied. Mr. Rose then said the defendant closes, and it then re-raises this request again, and the court said denied. So there are at least 3 times that the oral request for directed verdict was raised and denied. After the jury was discharged, the trial judge was apparently struggling with the question of Mr. Hernandez's employee status, and he appointed El Paso attorney John Mobes as a special master to answer the question of whether there was enough evidence to submit to the jury the question of whether Hernandez was King Aerospace's employee. Was there enough evidence for a jury to get that question? That was the charge for Mr. Mobe. He filed a special master's report, 30 plus pages, went through everything, and he concluded that the evidence was sufficient to submit the question and that King Aerospace had not proved as a matter of law that Hernandez was its employee. No motion for JNOV was ever filed, but a motion.
If I could interrupt you,
Sure.
and let's agree maybe that a judge cannot sua sponte grant a JNOV that's never been filed, but can a judge disregard an immaterial finding sua sponte?
I would say yes, a judge can disregard an immaterial finding. That's one of the few exceptions to the requirement for a motion for JNOV, but there can be no viable claim that whether Mr. Hernandez was an employee of King Aerospace is an immaterial finding. It is the central core issue that underlies this lawsuit. And so I would say that though a judge has that authority, it is not even risen. That issue is not arise in this case. It's the core issue. It's not immaterial.
And this question may be a little off the wall, but your request for relief is for us to enter judgment on the verdict, which I guess would mean we would have to do all the interest calculations, and I don't know if they're credits or subrogation interest or that kind of thing, or we remand it back to the trial judge for the trial judge to then hear the motion to enter judgment. But if we remanded it back, doesn't the defendant then just file a JNOV, and we're kind of right back to square one, which is trying to resolve the core issue of this, whether they've established that question as a matter of law?
I understand the question, and it is in part of the argument presented by King Aerospace. And I would say that if you are not to reverse and render the judgment that should have been rendered by the trial court, which is what TRAP 42, I believe, is the option, is one of the options anyway. If you do not do that, then what happens is we have come to this court with a burden that is not ours because the JNOV motion was not filed. It reversed the burdens. We have presented this appeal trying to second guess what complaints might be, not only about the evidence, but also to avoid any waiver about liability and damages. And I would say that is inherently unfair. The motion for JNOV was never filed. And at this point, Mr. Hernandez is entitled to a judgment on the verdict. And if the question is, can you figure out what the various interest rates and credits and all of that is? I understand the reluctance of an appellate court to jump into that. A A form judgment was presented with the motion to enter judgment by Mr. Hernandez's attorneys. And so that is available to the court if it were to enter a judgment as we have requested. But if not rendering a judgment as we have requested, then I think the judgment, the remand to the Court of Appeals would have to be the judgment is reversed and the court is instructed to enter judgment in accordance with the jury's verdict, because no JNOV motion was pending, and that's the judgment we're entitled to. And if at that point, King Aerospace decides that it will in fact file a motion for JNOV, then it can do it with its burden on its plate, and Mr. Hernandez is responding to that burden instead of assuming a burden and having to take kind of shots in the dark at what we think their arguments might be. I think that is not only the fair thing, it is procedurally and fundamentally a matter of due process. And Mr. Hernandez is entitled to that, and his attorneys were entitled to the kind of notice that one gets if a motion is pending. And that motion was not pending. And at the hearing on the motion to enter judgment, I might add that you can word search that part of the transcript, and directed verdict and JNOV and motion for directed verdict, those terms are not there. That was not even mentioned. And so I think it's a matter of fundamental fairness that he attended that hearing, his counsel attended that hearing on a motion to enter judgment, knowing that for 4 months, despite being told that such a motion would be needed, none was filed, despite having a thorough report from the special master saying you've not established as a matter of law this employee status. The attorneys were blindsided, quite frankly.
And can I ask this question, counsel? I don't want to get you off your procedural question, but I do.
Your Honor, there are cases that there are arguments that we prepare for and arguments that we give, and I'm willing to give whatever argument you want me to answer. Okay,
well, and this kind of expresses my confusion or my struggle with this area of law. And if you read the El Paso Tool and Die case, you understand part of that. But it seems like there's kind of when we talk about someone's status, there's kind of a continuum. And on one side, you might have a pure independent contractor for which there's no control. And in that case, King Air wouldn't be responsible. And then you have an independent contractor where there's some control over the injury cause and event. And then you kind of fall into Rettinger, and that's kind of where King Air might be liable under Rettinger. And then you move further along the continuum, and I guess you get to borrowed servant, and then eventually on the far end, just an employee. And so my struggle is kind of to try and find what is the dividing line between an independent contractor or a contractor where there's Rettinger type control to where, and it divides it from the next segment, which is a borrowed servant who can then claim the exclusive remedy from King Air. If I'm making my question clear, I hope.
Yes, sir. To the extent that I will try and answer to the best of my knowledge. And I would start by saying, I don't know that there are bright line tests. There's a continuum, as you have described. There is a continuum. But what we do know is that the right to control, the evidence on control, the evidence on the indicia of control and of employee are inherently fact questions. And the cases are replete with that. These are fact questions. And so what you have is a series of factors that are presented to the jury. And it is their responsibility to make that decision. You might like or dislike what their decision is, but it is ultimately a fact question for the jury to decide. So in this case, you have testimony from multiple witnesses, at least 3 witnesses, ATG employees, which would include Mr. Hernandez, that there was no control or direction of their work by anyone from King Aerospace, that the man with whom they had the most contact, Mr. Torres, was the self-described big picture man. And he interacted with the on-site supervisor our on-site manager from ATG, and he gave general ideas. This is what I would like to accomplish maybe today, or maybe this is what I would like to accomplish for the week. And then it was that on-site ATG supervisor who doled out the work, supervised the work. And significantly, Mr. Torres, the King Aerospace employee, testified that it was not him or anyone at King Aerospace who controlled the details, the manner, the means of how these individuals did their job, that their work was controlled by the FAA approved OEM manuals. And these employees of ATG testified they went to the manuals for all the information about the details, and that's what controlled their work. And in fact, if they couldn't find the answer in the manuals, they might call up the manufacturer itself to get the information that they need to perform the details of their job. So if I can circle back to your question, I think the answer is it is a continuum. And I don't know that we can have it as bright and as clear as some jurors may want, or certainly as some companies may want when they're using other employees. But on this record, they have not, King Aerospace absolutely has not shown that we are dealing with an employee of King Aerospace. Among some of the other factors that you might consider that were in the evidence are the pay, the W-2 information, the tax information, all from ATG. The ATG uniform was worn by these people. These individuals were skilled, specially trained individuals. They had limited access to the facility that King Aerospace ran, whereas King Aerospace's employees had full access. The ATG people had to be escorted, another indication that they were not employees of King Aerospace. And the documentary evidence that was introduced and raised and discussed in the briefing by King Aerospace, in particular, there was Defendant's Exhibit 4, which was a commitment letter. That letter differentiates the case from other cases for two reasons. One, ATG does not fit within the Chapter 91 organization for these employee organizations that loan or send out employees. So that's a different issue. But more importantly, their very own document, like the letter of commitment, Mr. Hernandez said, it's not mine. It doesn't have my name on it. It doesn't have my dates of service on it. It doesn't have the equipment or the aircraft on it that I'm working on. And he denied that it was his. So there's a fact question right there. The jury got to judge on that. But even more significantly, that exhibit and another exhibit, which included some records regarding him for work he had done previously with on the King Aerospace facility, those documents refer differently at different times. They call him an ATG employee, ATG provided personnel, ATG skilled personnel. They use different terms. So it was not very clear cut. Again, my whole point in bringing up all of this is that it is a continuum and there is no bright line. And that is why, one, if you want to set aside the judgment, you have to file a written motion for JNOV so that Mr. Hernandez knows what he's responding to. And two, under the basic principles of legal sufficiency of the evidence, which govern a JNOV request and govern, of course, this review that's here today, under those guiding legal principles, you have to view the evidence in favor of the verdict, not in favor of the motion for JNOV. And you can overturn the jury's verdict only if no reasonable juror could possibly reach the result it did. And the evidence does not support that very stringent test. And so in the end, what you have, and I mean zero disrespect, no disrespect, what you have is a request here that this court reverse and render a judgment as it should have been rendered by the trial court, because otherwise you have a judgment by the desire of a trial judge and not by the rule of law. I happen to like rules a lot. They give clarity, they give guidance, they give us the parameters of lawyers within which we are to work. And when those rules are not followed, and what you end up with is a judgment that I think the trial judge preferred the evidence in this disputed evidence that favored King Aerospace. But he was not the trier of fact. And the judgment that he signed incorporates the jury's verdict. On its face, it says the jury's verdict is incorporated. And then the trial judge finds, that is the verb that is used, finds that Mr. Hernandez is the employee of King Aerospace, and King Aerospace is entitled to the affirmative defense of the exclusive remedy. So, I mean, that in and of itself, that's an absolute conflict. And that is why, with zero disrespect, I say that we need rules to be applied so that we have jury trials that are governed by the rule of law and not by the particular desire of an individual judge or jurist. And for these reasons, I ask that this judgment be reversed and a judgment be rendered as it should have been in accordance with the motion to enter judgment. Thank you very much.
Mr. Rose, right? Yes. All right, you may proceed.
I think you're on mute.
Yeah, Mr. Rose, I think you're on mute. All right.
You're still on mute. Is that?
He's still on, yeah, he's still on mute.
Do you have the controls as the host, Justice Rodriguez?
Don't believe so.
Oh, no, no.
I can't read that either.
Oh, he's trying to show us.
Is he?
Ah,
Nope.
Maybe if he like signs out and signs back in, I don't know.
you can certainly try that, Mr. Rose. You can sign out and sign back in if you like.
Judge, I'm sorry. If you go to participants, Judge Rodriguez, you might be able to
Okay.
unmute him.
Okay. No, it doesn't allow me to.
Okay, 30 seconds.
There you
Oh, there
go.
we go.
We're live.
Can you hear me now, Your Honors?
Yes,
Yes.
yes.
Gotta love technology.
It's been that way
It
all
gives us this
morning, so.
opportunity.
Or not. Yeah.
Or not.
Yeah. All right.
Well, thank you
All
for
right.
your patience,
No problem.
Your Honors. May it please the court? Again, my name is Brian Rose, and I have the honor of representing King Aerospace in this appeal and at the court level. This court should affirm the trial court's determination that King Aerospace was an employer, of Mr. Hernandez. It proved this affirmative defense conclusively as a matter of law, and the appellant has raised two issues: one procedure, and the second substantive. And I'll get to the substantive part, especially in regards to the questions by Justice Alley and El Paso Tool. But first, for the procedure. The court didn't, we can all agree, the court did not enter a JNOV. No JNOV, no motion was filed, and nowhere in the record is a JNOV referred to. What is clear in the record is that during trial, during the multiple times I raised a motion for directed verdict, on the very first time I raised the issue at the close of plaintiff's case, the court said, I'm going to carry this motion. We'll see what the jury does, and I'll give you a ruling before a judgment is entered. Now, I understand that there is some text from the transcript that has a pause, and then it states, but you'll have to move for a JNOV. I was there. I remember it, but it doesn't matter. We don't have to go to what is or isn't in the transcript, because all you have to do is go to the court's order of September 3rd. This case went to the jury on August 24th. Jury rendered a verdict. On August 27th, appellants filed a motion for entry of judgment. On September 3rd, the court issues an order, and I'm going to present this to the court. This is the order, where the court specifically states that defendant had made a motion for directed verdict, which the court took under advisement. And at which point he says this is an exceptional case and appoints a special master to evaluate the issue of whether or not there was evidence sufficient to allow the submission of this issue to the jury for its determination. That's important, Your Honor, because at this point, there's no question what the court is doing. The judge's own words said, I carried a motion for directed verdict, and I'm appointing a special master. At this point, if there was any confusion by appellants, they should have objected and preserved the error. They should have said, Your Honor, I don't believe this is proper. I'm objecting. What you're doing is actually a JNOV. There's no motion for that. That's improper. That would have provided King Aerospace an opportunity to then file a motion for JNOV. And again, at this point, no judgment's been entered. There's nothing. Rule 268 does not have a timeline for entry of directed verdict. So we have.
Mr. Rose?
Yes, Your Honor.
Sorry. Was there any discussion about this during the jury charge when it was presented to the jury? Or at some point, isn't there a decision made that this is a jury question, therefore we're putting the jury to work on answering the question? And in that case, then the directed verdict as to this issue was fully resolved.
Your Honor, I can't find any case law for that proposition that once a jury has been given the charge, that a court can no longer grant a directed verdict. In fact, in our briefing, we cited to several cases where that happens, and it's happened to me in a previous trial. Judges that do this, and there's no rule. Again, 268 doesn't say, hey, once the jury is charged, you can no longer grant a directed verdict and you have to file a JNOV. You have to enter the verdict that's entered. Again, our procedure is jury returns verdict, then a judge can enter judgment on that verdict. And so, I have found no case law for the proposition that once the jury is charged or a verdict is rendered, a directed verdict cannot be entered. I just can't find one. And the cases cited by appellants, which would be In re Beadle and Allison, I believe. Allison is a criminal case which has to deal with in 1941, a judge calling back a criminal jury and having them enter two different verdicts. And In re Beadle is a case where, while it's civil, that too involved a judge impaneling two separate juries for a bifurcated trial. So we had one jury returning a verdict and then one jury listening to the evidence for damages. And so neither of those actually are on point in any means towards what we're here to talk about. There is no case that I could find for the proposition that 268 has a deadline prior to the entry of judgment, anytime before the entry of judgment. I'm going to just tag along with what Judge Palafox. To me, a directed verdict is for the court to render a verdict based on the evidence and deprive the jury of the opportunity to render a verdict. And so the idea that you could have a directed verdict after the jury renders a verdict is just nonsensical to me. It just doesn't make any sense. And Your Honor, I can understand that trail of thought. And again, in practice though, Texas courts routinely grant directed verdict after a jury has come back with their own verdict.
Routinely.
I'm not,
So
I don't think it, I'm sorry, Your Honor.
you said routinely. So there are a number of cases that you cite to that.
Your Honor, I believe we cited to 3 cases. If you give me one moment, it would be and of course, I relied more on well, Your Honors, I'll come back to that. I don't want to take up my time looking through those cases.
No, that's fine.
But
They're in your brief,
but Your
I'll
Honor,
find.
So can I
But Your
just,
Honor, that also brings me to the preservation issue in which we cited to Walmart McKenzie. That again, if this is error, appellant should have given the court an opportunity to correct that error by objecting. Again, this isn't a surprise. The court all along told us what we were doing. There would be no point of appointing a special master if we're not considering the directed verdict, which in his order he states he's considering. Because what's the point of having a special master at that point? Appellees have not filed a motion for JNOV. There's no judgment that has been entered. And so Rule 301 never came into play. And to now say, oh, wait a minute, while the court said it was considering, it carried its directed verdict and it was still considering it in its order on September 3rd, at that moment, appellant should have said, I object, this isn't proper. What are you talking about, Your Honor? Respectfully. And that did not occur. And so we are now here. That could have been solved then. They could have raised this issue. The court could have then decided, I'm granting a directed verdict. I disagree with your objection, or I agree with your objection. Thank you for correcting me. Mr. Rose, I'm going to enter this judgment. And Mr. Rose, you can file your judgment, not JNOV.
well,
And so I think, I'm sorry.
Did King Air object to the question being submitted to the jury?
Your Honor, other than moving for directed verdict multiple times,
No, well, when
that what I would say is my objection.
well, I meant
I object to multiple.
with the jury
Sorry.
charge itself.
To the question being submitted itself, we did not object to the question of employment because I did not believe I had that opportunity at that point. Once the judge said, I'm carrying your directed verdict motion, there was nothing inherently wrong with the question. I agree that in some cases, in a lot of cases, that is a fact question for the jury. I would posit to this court that in this case,
Wouldn't you need to preserve error at that point to, object to the jury question?
object to the question being,
I mean, that was your affirmative defense. I mean, you needed the question to be asked whether or not Hernandez was an employee based on the facts and the evidence that was presented of King Aerospace. So you didn't object to that question because that was the heart of your affirmative defense, right? Okay.
thank you. Yes, Your Honor. Thank you, Your Honor Rodriguez. I appreciate it. That is exactly true. I had to go at that point. But that leads to the substantive issue with this case. And that shows you the issue that this creates. And Justice Alley, in your concurrence in El Paso Tool, you raised the issue of, is there ever a way that we can resolve this issue without being a fact issue? And I would say this is not the case for this to be an issue in, because the evidence, the competent probative evidence conclusively established that Mr. Hernandez was an employee of King Aerospace at the time of the injury. There's two issues.
If I can just ask a couple questions and that maybe
Yes,
they're
Your
just imponderables, but if you're trying to establish that he's an employee as a matter of law, I still kind of want to know, is there a point on this continuum that you can articulate that divides between a contractor for which there's control that gives Redinger liability to where then you cross over and all of a sudden you're an employee or a borrowed servant? How do you articulate that dividing line? Maybe it's not crystal clear, but at least it's got to have a warm fuzzy to it.
Well, and let me attempt, sir. So in this case, we don't have the independent contractor issue. The judge specifically stated during trial that there is no evidence of him being Mr. Hernandez being an independent contractor, and that is not before the court. It was not raised on appeal either. So now we're looking at borrowed servant all the way to the other end of employee. And I posit to this court that the only evidence and the argument made by appellant to claim that he's not an employee of King Aerospace is a claim that he's solely an employee of ATG. And that fails for multiple reasons. First, under Mosqueda, the testimony of an employee subjectively stating what he believes he is no competent evidence and has no probative value. And that's what we had in this case. Mr. Hernandez saying, I'm only an ATG employee. But then you look past that. We'll put that aside. I'm going to present to the court Exhibit 4, which is the ATG letter of commitment. And it specifically states, work to be carried out in accordance with and under the direction of King Aerospace Management. And I understand appellant and Mr. Hernandez testified at trial, well, that's not mine because it doesn't have my signature, but he testified that he could not say that there were different terms on his, and he didn't have his letter of commitment. But even if you're going to say, okay, well, then that puts that aside, which again, I think that contract takes us past Phillips, which we cited to in our case, in our brief. If you look at the actual incident in question, there is no dispute that on that day in question that Mr. Hernandez was at King Aerospace's facility at Fort Bliss in the furtherance of King Aerospace's business. King Aerospace is a Part 145 repair station that had a contract with the military to repair aircraft. These contracts with the military are every 2 years. They cannot carry a staff that could handle all of this work on a regular basis. And there's testimony by all three, Mr. Hernandez, Mr. Quijas, and Mr. History. No company has a complete enough business to keep on hand more than enough mechanics to handle these influxes of aircraft. Second, ATG employees, while they came through ATG and ATG paid their payroll, did their tax, issued their W-2 and gave them a T-shirt, there's no evidence ATG ever took any control over these employees. ATG isn't in the business of aircraft repair. They're not a certified repair station by the FAA, which is King Aerospace. So there is no undisputed fact that on the day in question, he's at King Aerospace's facility on King Aerospace's contract for the military repairing aircraft. Second, so that's 1 and 2, their facility and furtherance of their business. Third, the incident that caused the injury, who's controlling Mr. Hernandez at that time? It's undisputed. King Aerospace trained Mr. Hernandez and all the other ATG employees on ladder safety. And Mr. Hernandez freely admitted at trial, I received that training. That training specifically stated, when you're at King Aerospace facility using King Aerospace equipment, which this ladder and stand were, you shall not put a ladder on top of a stand because that creates a fall risk.
Counsel, if I could interrupt you again. I mean, your argument seems to be following the Garza case and the 3 factors that it looked at, the last one being the injury-causing event. But after Garza, this court decided a case called Painter, in which, in a little bit different context, but it was whether an employer was responsible for its employees' actions. We broke it down to kind of a task-by-task question as to whether for a specific task with someone in the course and scope of employment. And that case went up and the Supreme Court said we were wrong about that. So my concern with Garza is whether we should be looking at a task-by-task question or whether we look at it overall. In other words, we can't say that he's an employee when he's walking up a ladder, but when he's back in the tool room, he's not an employee. That's kind of what Painter is telling me.
And Your Honor, I agree. I understand that issue and I agree with you. I think on a macro level, it's undisputed that he was a King Aerospace employee during his entire time. King Aerospace decided the hours of work. King Aerospace told them what to do and when to do it. King Aerospace was the one that was in control of whether the work was satisfactory. Appellant has raised the issue of, well, he wasn't supervised directly by King Aerospace. It was by Mr. Quijas, an ATG employee. Well, the record is clear and it's not disputed. ATG provided resumes at the request of King Aerospace. King Aerospace calls ATG and says, I need 8 mechanics with these different capabilities. Provide me resumes. King Aerospace then picks out which people they want, and then King Aerospace assigns those mechanics to the job at their facility. So in this case, Mr. Quijas was assigned to be a supervisor or lead. Mr. Hernandez was selected to be a sheet metal mechanic. King Aerospace provided all of the training. King Aerospace including the specific training involved in the accident. King Aerospace provided the tools, the manuals, and then finally,
I thought the employees, excuse me, I thought the employees brought their own tools, that they were etched.
They brought it.
And the King Air provided, the sheet metal or the paint or whatever, the supplies, but that.
Yes, Your Honor. All FAA A&P mechanics are required to have their own toolbox etched. It's for safety, so that if you drop a wrench and you can't say, hey, I don't have all my tools in my box, we need to go look inside the plane to make sure that that wrench isn't in the plane. So that is kind of a basic need. Again, Mr. Hernandez testified at trial, all of the tools needed for the work, the lifts, the ladders, the paint, the tape, the safety equipment, all of it provided by King Aerospace, and that he didn't use his toolbox that often. And so again, it's the totality and it's the competent and probative evidence, Your Honor, I think that we have to look at. And I refer to that as the macro level. On the macro level, yes, he wore a t-shirt that said ATG. Yes, he received his paycheck. He had never been to ATG's facilities. He had never spoken with anybody at ATG other than to get the letter of commitment. And so I would posit to this court that there is no evidence of any control taken by ATG. And so we don't have the issue of independent contractor before this court. And therefore, it's as a matter of law, he's the employee of King Aerospace. And so I think again, macro, micro, if you're worried about the court saying you can't look at it on a case-by-case basis, which, Your Honor, I would respectfully state that I think under workers' compensation analysis, the Garza test states at that time, and the court has not reversed that yet. But I don't think we need to get there. And then we have to look at this from a public, a public policy issue. The Texas Workforce Commission, the law states if you're an employer and you have workers' comp insurance that covers employees, that you get a bar, that you're protected. And so
let me push back on you a little bit just on that, and it's more a question of curiosity. But I mean, you have two sophisticated entities, and I'm puzzled why they don't have a contract that kind of clearly says, look, we're under Chapter 91 for an employee leasing company, or we're under Chapter 93 for temporary employees. I mean, if you're trying to place yourself under the act, I'm just puzzled. Why don't you do it? Why don't you have a contract that defines yourself under those two safe harbors?
Well, I'd say this, Your Honor. King Aerospace didn't leave it up to that. They had insurance that covered their employees. There was no question to King Aerospace that they had control of these employees on their contract, signing off on their work. And so they were the responsible citizen. They followed the law. They procured insurance that covered its employees, all of its employees. And so I think it deserves, under the law, the protection given to it, just as Mr. Hernandez received workers' compensation coverage from ATG, another of his employers. Again, this case isn't one or the other, it's dual employers. And I think that was conclusively proved at trial. And so I appreciate this court's time. Thank you, Your Honors.
Thank you.
All right, rebuttal.
Thank you, Your Honors. I think this argument illustrates for me very clearly and supports the argument that I'm making about the need for a written motion for JNOV so that the party who is in the recipient of a jury verdict knows what the challenges are and knows how to respond to them. It's a matter of fundamental fairness. And so we're hearing arguments today that are more appropriately, would have been appropriately placed in a motion for directed verdict. So I'd like to go back to just a few things that have been said. First of all, as to the directed verdict, I understand that the September 3rd order appointing the special master makes reference to a motion for directed verdict taken under advisement. I understand that. That signals to the trial attorneys that the trial judge has concerns about the employee status issue. But it does not signal to the trial judge, to the trial attorneys, that somehow after the jury has been discharged, after the jury has responded to the jury questions, after the jury is no longer under the control of the trial judge, and after the jury is free to talk about the case and thereby be influenced by others who are not connected to the case and by matters that are not evidence in the case, that somehow a directed verdict can be established. It cannot be. It is an oxymoron. You cannot direct a jury to return a verdict when the jury is discharged. So we are now at the next stage. The most that these trial attorneys could expect was a motion for JNOV. They understood that the trial judge had some concerns about this. They understood it. They also understood, as did King Aerospace, that the trial judge said, you will need to file a motion for JNOV. That's in the record. I didn't make it up. It's there. Nobody disagrees that it's there. So what do these trial attorneys expect other than, okay, we're going to have a little more work done on this. And then perhaps after this special master's report is issued, perhaps then King Aerospace will file a motion for JNOV and we'll dig in and we'll respond. Well, that did not happen. And I do not believe that there is any waiver on the part of Mr. Hernandez of a failure to file a motion for JNOV. That is completely a voluntary matter, for a strategic matter for that matter. It's a strategic issue for King Aerospace to determine, do they want to file a motion for JNOV or do they just want to go up and appeal it or do they want to pay it? We have no idea. And we certainly have no responsibility to say, oh, by the way, aren't you supposed to file a motion for JNOV? It would be like requiring someone who has a jury verdict or a judgment to say, oh, and don't you want to file a motion for new trial? Your 30 days are coming up. That is not the burden of the plaintiffs in this case who had the verdict. It is not their burden. So I disagree completely on anything related to the directed verdict. I would also remind the court that there are cases saying that it is clear error to grant a JNOV without a written motion. And at least one court has said that the written motion is jurisdictional. And there's no way to look at this judgment other than to say it is a de facto JNOV. It incorporates a jury verdict and then it finds completely opposite of the verdicts, the jury's finding in the verdict. So this is a de facto JNOV. It's improper because it has no underpinning motion, which would have probably clarified matters for all parties involved, and we would be having a different appeal at this point had the rules been followed. As for the idea that the evidence establishes as a matter of law that King Aerospace is the employee, obviously we have very different readings of the testimony. You cannot absolutely disregard testimony from 3 witnesses indicating they are employees of ATG, one of whom is a supervising employee. You cannot disregard the testimony of those employees that they got their direction and control over and information about the details, about the manner and means of doing their job from FAA approved manuals. And in fact, as I mentioned, Mr. Torres, the employee from King Aerospace, admitted as much, that it was that the manuals that these employees would go to, that's what controlled their work. The ladder safety, as has been pointed out by Judge Alley, we don't want to go down to, well, they're an employee of King Aerospace when they're on a ladder, but when they're doing the riveting, they're not. I would add that as to the ladder, safety issue, the safety engineer expert who testified said the training that was provided was typical safety training, but that training as to the ladder was not about the details, the manner, the means, the control of how one does the job. It was about access to getting to the job, and the testimony, which goes to the actual negligence issue, the liability issue, the testimony was that using ladders on stands was a common practice. It was a practice that there was even a photograph, if I recall the record properly, of a ladder on top of a stand. No employee had ever seen anyone reprimanded for doing that. And Mr. Torres, the King Aerospace supervisor, said he had never reprimanded anyone for doing that. They did not have sufficient lifts. What was needed was some kind of an electronic scissor lift or an electronic lift, and they did not have that. And so in order to reach the height to access the job, that is kind of the makeshift that they did. Finally, I would like to add that, again, the argument clarifies, at least in my mind, the unfair burden that is placed on Mr. Hernandez because a judgment was entered without the proper underpinning motion for JNOV. He is in this awkward position of having to second guess or look into the future. What are the arguments that will be made? And instead of trying to uphold a verdict and a judgment on a verdict, he's really trying to be clairvoyant to see, how can I overcome this? This record does not support a finding that as a matter of law, Mr. Hernandez was an employee of King Aerospace. And that is the standard. And you have to look at this evidence in favor of the jury verdict, not in favor of the JNOV. And so the recital of evidence that we've heard does not apply. That very standard dictated by the legal sufficiency review that governs this. And so for, again, all of these reasons, on behalf of Mr. Hernandez, I request that this judgment be reversed and a judgment be rendered in accordance with the motion for entry of judgment and the judgment there. Alternatively, I would request that this judgment be reversed and the cause be remanded to the trial court with instructions to enter a judgment on the verdict. Thank you. I will answer any further questions you might have.
Counsel, I mean, if you know, and if the record says so, are there any issues with regards to the credits or offsets or subrogation interests that need to be taken into account in entering a judgment?
Well, I'll be quite honest. I'm at the same or not quite the same disadvantages as an appellate court, but I was not among the trial counsel for appearance in court. So I am unaware of those, but Mr. Rose would be, I'm quite sure. Thank you, Your Honors. Thank you, Your Honors.
And Your Honors, I appreciate Ms. Stone giving me that much.
I was just going to tell the chief she was muted, but she's not. I'm sorry.
Mr. Rose?
I didn't know if the court wanted me to respond regarding that last question from Justice Alley.
Judge?
If it's okay with the chief, just very briefly.
Please. Yes.
I appreciate Mrs. Stone's confidence in me, but at this time, Your Honor, I can't remember. I wasn't prepared for that question, to be honest.
That's fine. All right. I'm assuming that you have concluded. We're almost out of time. I want to thank both of you for your very excellent arguments and spirited debate. You know, this is an ongoing issue for this court, and I think courts around Texas. So, so we appreciate all the hard work that you've done and the time you spent with us today. So with that, we will submit your case based on the briefs, the record, and your oral arguments. Thank you.
Thank you, Your Honors.